LAWS11059 Statutory Interpretation. Thank you very much for joining us, and I do hope that you enjoy this unit. Statutory interpretation is particularly important for a range of reasons. It comes in at first year in law school, and it's designed to work in conjunction with Introduction to Law. Many of the things that we cover in statutory interpretation involve you having an ability to undertake some legal research. So do please ensure that you have access to reliable and authoritative legal research materials. The university has access through its library to the very best materials that you'll need, and that includes both paid subscription services and also free services like Queensland legislation and OSLI and J. Barnett. So there are a range of sources for you to access information about statutory interpretation and indeed the statutes themselves. When we talk about statutes, we're really talking about acts of parliament. So statutes are often called acts and are described as such. The Property Law Act 1974, of course, is a statute. And in the days when I first started studying and practicing in law, the statutes were recorded exclusively in written form in bound library volumes. As you might expect, libraries were huge, still are, but all based on paper. And one of the practical difficulties that we used to encounter was that as an Amendment Act came through, we would need to literally cut and paste those sections that represented the amendment and then paste it into, and I'm talking about with glue, into the original act. So when you picked up an Act of Parliament that had been subject to many amendments, it would run the risk of falling apart, literally, because we'd pick it up and bits of paper were actually glued in. It was, in short, difficult to keep up to date with what was the law in its statutory form until the advent and widespread use of computers. Now it's much easier because we have consolidated pieces of legislation online ready for you to access from multiple sources. But from time to time, you will need to consider what the statute said, the Act said at a certain time in the past. For example, in a criminal prosecution dealing with a historical matter, we may be more interested in that which the law was 10 years ago in a particular case than that which it is now. And I hope that makes sense, which leads me to a general basic principle about statutory interpretation, that statutes don't operate retrospectively. That's the basic rule. Therefore, given that's the case, you'll need to both have an ability to access up-to-date information and content of statutes, and also the statutes as they were in past points in time, which means advancing your legal research skills. I have prepared a number of videos in relation to legal research. I commend them to you. And these videos, which are in 4 parts, should be available on Moodle and provide you with an overview of how you can access not only statutes, but also case law. Speaking of videos, you'll see a number that I've created for general application. One that's particularly important, I think, for you to consider from the outset is a video that relates to how you prepare for examinations and how you prepare for short window take-home papers, which are really essentially examinations that you undertake at home. The basic principles apply, and I can summarize in this regard by saying you need to be well prepared. Now, what people think is well prepared varies from person to person, and I call it level 3 preparation for examinations and short window take-home papers, because in my view, you need to aspire not to level 1 preparation, which is what I've experienced most people think is preparation, go beyond level 2 and get to level 3. Have a look at the video, study it, and if you're happy to do so, embrace the concepts that I talk about. Do that early on so that you're now, from week 1, preparing for how you might go about answering the question at the end of term. All right, so statutes and statutory interpretation. Why is it important? Well, you will hear this year in year 1 and very often throughout your studies and indeed in practice that when we talk about the law, let's say in Queensland, we're really talking about 2 distinct subcategories. The first is primary sources of our law, and the second is the secondary sources of law. Now, most students in answering a problem tend to proliferate the answer with information from secondary sources, which is our secondary law. I'm going to encourage you from the outset to avoid that temptation and think about answering legal problems by reference to the primary sources of law where you can and to the extent that you can, and then adopt a mindset of supplementing that with information from secondary sources. So what are the primary sources? Primary sources essentially are statutes and case law. They're the primary sources of our law, and they work in conjunction. And the secondary sources of law are essentially those commentaries, such as this, that talk about the law and provide to some degree an opinion or a summary or an explanation about the law. So your textbooks, as good as they are, don't represent the primary source of the law. They're a secondary source of the law. Dictionaries, for example, are secondary sources of the law as well. They supplement, but they don't replace, and they shouldn't be the first point of call. So if you're answering a legal problem, it would be unusual to reference your material by that which was said in secondary sources, especially when the answer to the problem lies directly in primary sources of the law. So adopt that mindset. Now, within the context of primary sources of the law, statutes, acts of parliament, and cases, bear in mind that where there is some conflict, should that arise, then it's the statutes that prevail. So of the primary sources of the law, the statutes are the more important. Now, you can see where I'm in part going with this, that if statutes are the premier source of our primary law, then we need to know how to read them and interpret them and apply them correctly. And given that we've devoted a whole unit to this topic, it's not as easy as you might think. Let me give you some examples of that. I'm going to attempt to share the screen. I hope that this doesn't lock me out. The bandwidth should be fine for this to happen. On your screen now, you should hopefully see the Civil Liability Act 2003 Queensland. If I've mucked it up and you can still see me, please go to the Civil Liability Act 2003 Section 12. It says, and it's very short, it says, onus of proof. In deciding liability for breach of a duty, the plaintiff always bears the onus of proving on the balance of probabilities any fact relevant to the issue of causation. Okay, so that's what the primary source of our law says. But let's just take a moment to analyse that. The first thing is that you'll see there's some hint about the degree to which that law applies in the name of the Act. The first thing is it's a Queensland Act. it's a Queensland Consolidated Act. Therefore, you'd assume that it applies in relation to matters pertaining to disputes in Queensland or that have a nexus, a connection to Queensland. You wouldn't readily apply this law when you're dealing with purely a dispute that relates to matters in South Australia. You'd look to South Australian law. That might seem a bit obvious, but you need to keep it in mind. And that's a hint from the Act. It's the Queensland Civil Liability Act, or the Civil Liability Act 2003, open brackets, QLD, close brackets, more particularly. The second thing is, because it's a Queensland-based act, then you can assume that it wouldn't generally have application to Commonwealth matters. And bear in mind that in Queensland, we have, that sit side by side, pieces of statutes that are based from Queensland Parliament as Queensland Acts of Parliament statutes, and we have the federal or the Commonwealth Acts of Parliament. For example, the Family Law Act 1975, in brackets CTH, Commonwealth, or sometimes CWTH. So we have to determine within the context of a statute whether it's Queensland or Commonwealth. And to cite that act correctly, you should include the name QLD as part of the citation. Let's go back to section 12. It talks about, it's the Civil Liability Act 2003. Now, there's a word in there that really stands out to me, and it's the word civil. You'll see regularly the distinction between that which is civil against that which is criminal. They're a part of the basic categorisation of our laws. So I get a hint already from the heading to say, okay, this is not a statute that I would refer to in an argument based around criminal law. It doesn't say in the section that it relates to civil law only. On the face of it, it might apply to criminal law, but the heading tells me it should relate to civil law. Then it talks about the onus of proof. Proving, I guess that's pretty obvious, proving something, we're familiar with that. What do we mean by onus? O-N-U-S, you'll see this a lot. And you'll often see it contrasted to another legal term, which is standard of proof. Now, a legal synonym for onus is burden. Whose job is it to prove? That's who's got the onus to prove something, as opposed to the standard of proof. And generally, in the standard of proof, we talk about the distinction between balance of probabilities and beyond reasonable doubt. Balance of probabilities is something usually associated with civil law, and beyond reasonable doubt is something that's usually associated with criminal law. And even though this section talks about onus of proof, when we come to read it, you'll see that it actually goes into dealing with standard of proof. And there's a phrase there on the balance of probabilities that really talks about standard of proof. So perhaps the people that prepared the legislation could have called it onus and standard of proof in civil disputes. So sometimes a heading of an act and sometimes the name of a section will give you a hint as to what it's all about. So if you just read the words of the section without considering other things that might provide you with some hint as to how to interpret it correctly, you run the risk of falling into error. So you've got to look a little more broadly, and I'll encourage you to look a lot more broadly, but for the moment, a little more broadly than just the words of the section. The name of the act and the name of the section are also guides to interpretation. Let's look at these words, and it's a very short section. In deciding liability for a breach of duty, I'll stop there. So who is this section designed, who is it aimed at? It talks about in deciding liability. That suggests to me that it's a section designed to talk to a decision maker. So to expand on it, you being a member or magistrate or judge, if you're deciding something, here's the way in which you're required to do it. And remember, of course, that primary sources of law speak to a greater authority than secondary sources, and primary statutes speak with greater authority than case-made law. So here's Parliament directing courts, it would seem, as to how to go about deciding matters relating to a breach of duty. Now, the term liability is probably straightforward, who's responsible, but it may be that in a civil dispute, it's not cut and dry, it's not black and white, it's not 100%, 0%. There are a lot of shades of grey in law. So maybe when we're talking about liability, you start to think, well, is it possible that liability means more than 100%? Can there be shades of grey? Can there be liability that's split between the plaintiff and the defendant? And how do we find out? Let's move on. A breach of a duty. Well, what duty? Where do I find these duties? What type of duty are we talking about? I need more information. The plaintiff always, well, that's pretty straightforward. It's never reversed to the defendant. Always bears the onus of proving on the balance of probabilities, which is essentially more than 50-50, any fact relevant to the issue of causation. So any fact has to be decided on the balance of probabilities. Now, some facts are more important than others when it comes to deciding a legal problem. In this instance, you might think that some are fairly basic facts, easily proved. Other facts, which are critically important, might be more difficult to prove. So when we talk about the degree or the standard to which they're to be proved, the Act says on the balance of probabilities, more than 50%, let's say. But sometimes you don't need much evidence to prove it. It's pretty easy to prove a particular fact. Other facts, you might need a lot of evidence. Now, this is where, you'll hear this quite often in law, a common law case of Brigginshaw comes into play, because when we're talking about proving something on the balance of probabilities, quite often that civil standard of proof is made subject to the test in Brigginshaw, which essentially means this. The degree to which a decision maker is satisfied about a fact may depend on the importance of that fact. In other words, if something is particularly significant, particularly important, even though the plaintiff needs to prove on the balance of probabilities, they may need some very cogent evidence to satisfy the decision maker about that. And then there's any fact of an issue of causation. So what do we mean by causation? So when I read that section, and I do so critically, analysing it, so to speak, looking for missing detail, I can almost very quickly raise many more questions than I do answers. So statutory interpretation then is really all about how do we find the answers to those questions that pop into our mind relevant to reading a statute? Where do we look for more information? Let's go back to the Act and I'll share the screen. When it comes to looking at legislation, you need to look quite broadly. And by that I mean, my recommendation is before you seek to apply any legislation, you read the content page carefully to get a feel for it. Look at the chapters, get a feel for what each of the chapters says. Look at the parts within the chapters. Sorry to scroll so quickly there. And then think about ways in which the Act itself might assist you in interpreting the provisions. So we call that using intrinsic materials, that which is contained within. And a couple of great starting points to determine intrinsic materials by reference to intrinsic materials are generally the long title, which replaces the old-fashioned preamble that you might see in older legislation. Then you might look at issues around the principles that are applied in the Act. Definitions, of course, are always very important. And then you consider the chapters and the headings to get a feel for what's contained within that chapter. So you'll see that section 12, that deals with Division 2 causation, is part of Part 1, breach of duty, which relates to Chapter 2, civil liability for harm. So those major headings give you a better idea of how to target your interpretation of, in this case, section 12 of the Act. All right, let's have a look at another piece of legislation. That is the Civil Proceedings Act 2011. Again, Queensland, section 8, likewise a very simple looking section. If a court has jurisdiction to hear an application for an injunction or specific performance, the court may award damages as well as, or instead of, an injunction or specific performance. What does that mean? How do we best understand what that statute is attempting to say? Again, we look at the Act. Again, we have the word civil, doesn't apply to criminal proceedings. Equitable. Now, you'll hear this word a lot in the study of law, and we contrast equitable generally to that which is legal. Now, you might say, but isn't this all legal? Now, in Introduction to Law, you may, and I touch on this in my legal research videos, but there was a basic distinction. There's a basic distinction between the law, which was applied very strictly, black letter law, if you like, and the law that was applied in an equitable manner, which is all about fairness and receiving a just outcome that had the aim of softening the hard letter law. Abbreviated, they became law and equity. And in the Middle Ages in England, people would make an application either to the courts of law or to the courts of equity, which were also chancery. And they're quite distinct. Essentially, the laws relating to equity were handed down directly by the King or Queen to the Chancery Court, and their basic aim was to look at all the circumstances and come up with a fair result, something that was equitable. The strict application of the law was probably more often used by landlords and moneylenders, and where they wanted strict compliance, no excuses. Eventually they merged, but it's not a complete merger. So you'll still see reference to that which is equitable and that which is legal, and the distinction. The Judicature Act of, I think, 1873 applied to merge those in a more practical sense, but you'll still see it. So think about that which is based in equity and that which is based in law. And in third year, I think we've got, and I have taken this unit, we have equity as a unit. as a standalone, and that gives a lot more detail to what I'm briefly describing to you now. Let's go back to Section 8. Section 8 says, if a court has jurisdiction. Now, what does that mean? It suggests to me that not every court has jurisdiction. This isn't talking to necessarily every court, because it says if a court has jurisdiction to hear an application for an injunction or specific performance, then certain things can happen. All right, I now know by reading that section that some courts do have this jurisdiction and others don't. I better start to put together some notes. So I've got an idea of which courts can do what in general terms, and then I can add to that and expand on it down the track. So what does the word jurisdiction mean? Well, jurisdiction basically means the legal authority to undertake some decision-making relevant to the matter in question. I mentioned before that courts in Queensland don't on their face have jurisdiction to deal with matters that are purely related to disputes in South Australia. So an argument would be, you don't have jurisdiction. We shouldn't be here. So jurisdiction means the lawful authority to make the decision. Now, it has jurisdiction to hear an application. What's meant by an application? Can we contrast an application to something else? Are there different ways of initiating procedures? Is an application the only way? Are there other ways? We know this relates to civil, not criminal. For an injunction or specific performance, what do those words mean? Well, you'll see them often, and I can tell you now that injunctions and specific performance are both powers that are available to courts exercising equitable jurisdiction to make particular and particularly powerful orders. An injunction is an order generally given to stop someone from doing something, but it can be a mandatory injunction, which is to force someone to do something, or specific performance, which is also to force someone to do something. We see specific performance generally in the context of disputes about contracts, mostly real estate, where someone wants the other side to specifically perform the obligation. In other words, you've done me wrong. I deserve some remedy. Remedies are the general word for all the things that you can ask a court to grant to you. I deserve a remedy, and whilst generally my remedy is in damages, which is money, which is a common law concept primarily, in this instance, I want the court to order that person to sell the land to me because that land is unique and I don't wish to be compensated in money. I want that block of land. So that's an order seeking specific performance, compelling to go ahead. And as you can tell, there are differences between injunctions and specific performance that we can talk about later. But for the purpose of today, you can see that the court, if it has jurisdiction to hear those applications, then what can the court do? The court may award damages as well as or instead of the injunction or specific performance. Damages, generally speaking, a legal remedy, but you'll see from the actual name of this section that now what we're talking about are damages within the context of an equitable claim, therefore equitable damages. You won't be able to read that section in a meaningful way unless you go beyond the section. And that's what we're doing now. So again, if you want to go beyond that section, what you need to do is read more widely. A starting point, consider the Act as a whole, always. Look at the parts and the divisions. Now, this one doesn't have chapters. You note the difference between it and the earlier legislation? It goes straight into parts. So no chapters in this one. And you'll see that it has orders that are available in different circumstances. It does have a dictionary, always go to that. But you're looking generally at the start for some sort of indication as to the purpose of the legislation. All right, now we get to the most significant piece of legislation relevant to your studies in this subject. In Queensland, the Acts Interpretation Act 1954, there is a Commonwealth Acts Interpretation Act, and there are Acts Interpretation Acts throughout all the other states. They might be called slightly different, but they're all basically how to interpret an act. So, unsurprisingly, for a unit called Statutory Interpretation, and bearing in mind that a statute is also called an act, the Acts Interpretation Act has to be a go-to always. So keep it handy. This is critically important. And I'm going to finish now by inviting you to spend some time looking at that legislation, getting a feel for it, getting to know the specifics, and always asking yourself, how can I use that in a meaningful way when I'm answering a question relating to statutory interpretation? Thank you, and we'll see you in tutorials. Bye then.